Hello everyone, welcome to my channel. Now we are going to start with a new concept, that is tort. Tort is nothing but the civil wrong. Tort is occurred when there is a violation of the legal right. Every individual has some legal rights, and if such legal rights are violated by some person, then we can say that a tortious act is done by that individual. So, while understanding tort, there are four important concepts which it is important to understand. First is tort feasor. Tort feasor is the person who commits a civil wrong. So that the person who has committed a civil wrong is considered as a tort feasor. Second is tortious act. Tortious act is a civil wrong for which a person can be sued. It means a person or an individual can file a suit against such person who has done a tortious act. Next is plaintiff. What is plaintiff? It is simple. Plaintiff is the person against whom a civil wrong has been done. So to recover the damages and the compensation, the person can file a suit in the court. Then fourth is a defendant. Who is defendant? Who is accused for doing such civil wrong. Sometimes they are also considered as a respondent. So these four concepts are important if you want to understand the tort. Now next we are going to see what are the definition of the tort. There are different definitions of the tort, but there is no one universal definition which is accepted by all the scholars. But different scholars have given different concepts of the tort, or they try to define in a different ways. There is there are no codification of this tort. Tort is uncodified. So there is no one such definition given in any bare act. But in Limitation Act, they have said that the tort is not exclusively about the breach of duty and the breach of contract. There are three important definitions as far as tort is concerned. Salmon is saying that the tort is the tortious act has unliquidated damages, which is not exclusively the breach of duty and the breach of contract. It means if the tort has happened, there are unliquidated damages. It means such damages are not certain, they are uncertain. It is difficult to quantify. But it is not, it is beyond just a breach of contract and breach of duty. Then there is a Fraser who say that the tort is an infringement of a legal right in the name of individual to give rise to the compensation which can be filed at the suit of an injured. Then there is a Winfield who says that the tortious liability is arised from the breach of duty, which is primarily fixed by law. So Winfield has given important definition, but it gives important only to the breach of duty. Next, if you see the examples of the tort, then the examples are very simple. You can see such examples in day-to-day life. If any person injure the right of reputation of anyone, then this gives rise to the tort of defamation. It is a duty of every individual that you cannot abrogate or you cannot violate or you cannot infringe the right of reputation of anyone. And if you do so, then it gives rise to the tort of defamation. Same in case of the tort of trespass. Every individual has a right to property. And if there is a right to property, then a person cannot interfere with the right of property or with the property of the person who has the possession of such land. And if you do so, there is a tort of trespass. Same in the case of tort of negligence. It is a duty of an individual to take care, and if you negligently, even not intentionally, if you negligently do so, there is a tort of negligence. So these are some examples of different torts. Now, for the very important topic we are going to deal with, that is difference. RENCE. Difference between the tort and the offense. Now I have given mnemonics for this tort. Even you can write this mnemonics, or you can remember this mnemonics to give the features of the tort. Now we will see first what are those important points in a important points which deals with the tort. The same in a contrary you can use this while dealing with the concept of an offense. Now first is I. I stands for when tort is happened only against an individual. It means the tort, that is a violation of the legal right, and you violation of the legal right of an individual. The civil wrong is against an individual, not against the state and society. On the contrary, in an when the offense is happened occurred, this offense is against a state or against a society at the large. It is not against and only against only against an individual. It is against the state and society. So if you see a criminal matter in a court, then there is always you can see that it is state versus XYZ. So state is a plaintiff, and XYZ or any other party is a defendant. So you can see that offenses occurred, then always a state or the society is the one who is considered as a plaintiff. But if you see the tort, the civil wrong is only against an individual. It is not against the society or the state. Then the second important feature is that it is tort is if you want to take damages or recover the damages, or they want to take want to seek a compensation for such civil wrong, you have to go to the civil court, which is in case of offense you always have to go to the criminal court. There is a civil courts, you can file a suit in the civil courts. Then this tort is uncodified. It is not codified, it is uncodified. There is no bare act like IPC. You have IPC, you have CRPC, now you have BNSS, that is Bharatiya Nagari Suraksha Sahita. But as far as tort is concerned, there is no such bare act, or there is no statutory provision for this tort. Then it is P stands for preponderance of evidence. That means when the standard of proof in case of offense, it is always beyond a reasonable doubt. It means if you want to convict a person, then it is important for the prosecution to give evidences which are beyond the reasonable doubt. It means such evidences are 101% proved in the court. But in case of tort, it is not 100% certain. If the one party has more evidences, then then you can say they are more there is more probability that a court can give a decision in their favor. Second, negligence. Here, a negligence can be responsible for tort to happen. In offense, there is always negligence and there is no intention, but in offense, it is intentional. And 1, 2, 3, 4, 5, 6, and 6 important point is, I forgot what is the sixth point. I will tell you later. Next point is verb. If you say taught, there are three important essentials. What are those essentials? Just remember, build. Just uh, for the sake of exams, it helps you to remember those important points. First is wrongful act or the omission, then the existence of a legal right, and then it is damages. Okay, sorry. If the sixth important point is damages or the compensation. In the offense, you have the punishment which is already mentioned in the Indian Penal Code. But if you see in the tort, there are always the damages and the compensation. There are no punishment as such. In offense, you have life imprisonment, or you have jail for those, you have capital punishments, but it is not in case of tort. To tort, you may seek plaintiff can get a compensation and the relief for those wrongdoings by filing a suit in a civil court. And in case of offense, you will the for such offense, the accused can be punished for the same. Now the essentials. In essentials, the first is a wrongful act. There should be some wrongful act or the omission of the act. What is omission of the act? It means that if any person has a duty, that is a legal duty to do something, but if that person is fails to do so, then you can say there is omission of the legal duty. For example, when you ride a bike on the road and there is a signal, if there is a red signal, it is important for that bike rider to stop at the road signal so the people can cross the road. If you fail to do so, then you can say this is an omission of an act. You are supposed to stop by seeing the red light, but you fail to do so. It means there is a omission of the act. Same in then second important point is legal right. It means, for example, if any person have a right to property, and if a particular individual XYZ is interfered with the property or with the land which is possessed by some person, then you can say uh, there is a tort of trespass. So this is a violation of the legal right. So if there is a violation of the legal right, then the tort occurred. Then D stands for the damages. It leads to the, if there is a violation of the legal right, it gives rise to the damages. It means if there is a damage or the some damage to a legal right, then the person that is the plaintiff that can ask for the seek the damages and the compensation by filing a suit in a civil court. In case of tort, locus standi, The concept of locus standi plays very important. Where the tort is, where the situation, where particular act happened, where it is situated. But there is one exception, that in concept of PIL as a public interest like litigation, this locus standi concept doesn't apply. So keep this in mind. So today we we saw this concept taught. I know this concept is a little bit complex, but if you understand the basic concept like a tort feature, what is tort TS Act, some are important definitions, some examples. If you see the basic difference between the tort and offense, then it is very easy to understand. An important point here that it is a mnemonics, that ICU pay no disturbance. ICU pay no disturbance. It helps to understand what is the essential features. As we see this, there are three important essentials uh, for a tort to occur. But you can write these important essential elements as far as tort is concerned. There is a big difference actually between the tort and offense. Okay, that's it for the today. See you soon. Bye.